Good evening. Today is Thursday, not Wednesday, because Wednesday we had to transfer to Thursday, 9 o'clock. And my name is Alena Shautsova. We have our legal speaking seminar regarding employment authorization in the United States. Probably one of the most popular questions that I receive regularly regarding different immigration issues in the United States is how to get employment authorization. People ask me, can I come to the United States on a tourist visa and get employment authorization? Or they say, I've been here for a very long time, how can I get employment authorization? Well, the reality is that employment authorization does not come by itself in the United States. To receive it, you need to qualify for one of the specified immigration benefits. Otherwise, you cannot get an employment authorization. You either have to have, let's say, a work visa, a green card, or a U.S. passport to work in the United States, or employment authorization. So basically, to accept employment in the United States, a person has to be a U.S. citizen, a green card holder, the person has to have an asylee status, or the person has to have an employment authorization or one of the visas that allow them to work. It can be an H-1B visa, it can be an O visa, it can be some investor's visa, but they have to be a basis for an employment authorization. You cannot receive it in itself. Sometimes the law allows a person who is applying for certain immigration benefits when they're waiting for employment authorization benefits, for immigration benefits, to receive employment authorization. The most common type of these situations would be application for adjustment of status. In other words, somebody who's applying and waiting for their green card in the United States is allowed to work. They can receive an employment authorization. Unfortunately, many notarios, so-called, and lawyers who should not be really practicing law, they use this provision to obtain employment authorization for people, and they file for adjustment of status, knowing, or they should have known, that the person will never get it. But they promise the person that they will get them an employment authorization, and that's how they get it to them. They just apply for a baseless adjustment of status application, as they submit a baseless adjustment of status application, and with that, the person automatically receives an employment authorization. That's one of the instances when an employment authorization will be granted to a person before the person qualifies for an immigration benefit. Another instance would be when the person is applying for asylum in the United States. An asylee, after that asylee was waiting, or that person's application has been pending for 180 days, is allowed to receive an employment authorization in the United States. Now, important information for asylum seekers. An application for employment authorization for somebody who has filed for asylum can be submitted 150 days after the application was accepted, but will not be granted. The application will not be granted earlier than 180 days pass. And for years, somebody who did not receive the employment authorization within 90 days was able to go to the local USCIS office, and they would give them that's called in the meantime application. In the meantime employment authorization, while the main application for employment authorization is being considered. This procedure is no longer followed, and actually, according to USCIS, it has not been followed from 2008, I believe. So the only recourse a person has when the application for employment authorization is pending is just to wait, and they can check with USCIS, they can make an info pass appointment and check what's going on with the application, but they will not be granted this temporary employment authorization, at least according to the latest information from USCIS. So how do you get employment authorization if you are qualified for it? You need to submit a form I-765. You need to be honest when you're submitting this form. To the best of your abilities, you need to list if you ever applied for employment authorization before and what was the office and date and time, and if your application was granted. Many people ask all the time, I see those questions, what category do I put in? What category? Well, if you read instructions to the form, you will know what category. People who are applying for adjustment of status based on marriage to a U.S. citizen, this is one of the most common situations, will put C9 as their category. Very easy. People who are applying for asylee status, I believe A11. It's all in the instructions. You can verify this information just by simply reading the instructions. People who were granted VAWA, actually, they have different categories. I believe they have 3 different categories available to them. And they can choose it. And it depends on person's circumstances, what categories they should choose. So this is not the rocket science. You basically need to read the instructions and you need to follow the instructions. Sometimes, of course, there are legal questions. Let's say a person is confused, he doesn't know if he is falling under certain category, then the person would probably need to call a lawyer. And it's a good practice to have a lawyer filling out those forms. Even if the lawyer misspells your name or does not provide the correct date for you, you can easily verify this information. This is not important. What's important, because this information can be easily corrected by the lawyer, what's important is to make sure that procedurally that application is submitted correctly, that you will be granted employment authorization. And if a lawyer makes or paralegal makes a typo, it's not a big deal. We're all humans. It happens. So what's going to happen to somebody if they start working without an employment authorization? Well, it's going to be a problem. Because if the status does not allow them to work, if they're not a permanent resident, if they're not an asylee, a person who's been granted asylum, if they're not a U.S. citizen or fall under some other categories, the person cannot accept employment or be self-employed or owning a business if they do not have an employment authorization. It's a violation of the status. Many people in OPT ask this question. Can I open my own business if I have an OPT? Well, yes, but you have to have an E-verified business, and then you have to show that this business will not be considered non-employment if you don't make any money, and all other requirements. So most likely the answer will be no. As always, you are welcome to submit your questions regarding employment authorization through my website, www.shautsova.com, or by calling us 917-885-2261. I hope you enjoyed this presentation, and I'm looking forward to talking to you via email or via the phone. Thank you.